Good afternoon, my dear friends. How many of you, before I start the session on an eye on law, I would like to know how many of you know that we can be taken to court? I'm too short, I'm not visible. No, I just wanted to know how many of you know that we can be taken to court? Everybody knows? Okay, that's good. That's good because I've been, from the time I graduated in the year 2004, I've been giving lectures in a lot of places, and I've been to a couple of places where people don't even know that the doctors can be taken to court. So that was the state of affairs. So I'm very happy that at Raipur, even though your place has joined this particular state, yesterday only somebody was highlighting to me that only for the past 18 years, you people have come in separately, and Raipur is the city which is your capital city. All the stories I heard yesterday. So now coming back to eye on law. See, normally the three things which I would like to talk to you today is how to tackle a legal notice, and you must be hearing a lot about violence against doctors. The violence is really so pathetic that we start wondering whether we need to practice ophthalmology or any other specialty for that matter. So how to tackle legal notices is one thing, and violence is another thing. And third topic which I would like to talk to you is a very, very depressing topic, is the cluster endophthalmitis. So what is the legal system? What is the perception and what is the reality? For many physicians, the legal system is an uncharted territory. They have not dealt with this extensively with the legal process, and therefore do not know or do not have an in-depth knowledge of the way the system works. When facing a suit, the nature of the game, its rules, strategies, and all that is really alien to a physician. A malpractice suit is just a business to many lawyers and judges, because to a judge with 70 cases in the docket, or to an attorney who has been defending only legal litigations all the time, the malpractice cases for 10 years is a case simply a part of their jobs. But the litigation process for the medical mind works on a different premise than the legal one. It emphasizes independent judgment, the correct answer, and scientific evidence which establishes the truth. So, how to tackle a legal notice and what to do when a consumer case is filed against you? Remember that anyone can get a legal notice. Just because you have not got one, don't be very happy. It just says that you have not been doing enough procedures. If you are doing enough procedures, you will definitely one day get a legal notice. So don't get scared. Many a time, I have found doctors looking at people who have received legal notice as though they are from Mars. When you receive a legal notice, do not panic. Read and reread the legal notice very carefully and patiently, and send a reply as early as possible, stating that I categorically deny and refute the charges mentioned in your notice. I'll be sending you a detailed reply soon. Even if you have done something wrong, this is the way you should be wording it. After doing that, get the help of a good and a seasoned consumer expert lawyer. Do not get an inexperienced lawyer because your case may not win. You need to give a proper reply drafted by the lawyer and send it to the complainant within 30 days. See, I want you to listen to those numbers, like 30 days. Maximum, you can maybe extend it to 45 days. But if you give your reply by 30 days, that is acceptable, and that is the most favored thing. And next, case sheet forms a very important document in all litigation cases. So, please do not try to add or delete any information from the case sheet. In short, there should not be any tampering or correction done in the case sheet. If you have sought the opinion of a physician or surgeon or anybody else for that matter for your case, his instructions should have been carried out verbatim. And all cases undergoing surgery under GA should have been seen by an anesthetist at least a day or two before the actual procedure, except in emergency cases, 2 hours before the procedure is acceptable. As far as the consent form goes, getting signature of the patient on the consent form is a must if the patient is more than 18 years old. Now they have made it a rule that in addition to signing on the consent form, they want your digital thumb impression. Consent form should be written in patient's mother tongue, and the patient should sign it after going through it and understanding the implication of the procedure. And for people who are illiterate, you should make sure somebody who is knowledgeable, their neighbor or their ward, whoever accompanies them, they understand the implications of the procedure. And also, supposing, say, you have a particular case in which you can do in one or more ways. In such cases, you will have to explain to them the first method, the second option, and the third option if there is one. And consent form should be written only in handwritten and not typed as per the court of law. Before taking up a patient for eye surgery, the related complications including death has to be written in the consent form and explained to the patient. You might be wondering, can a patient die after cataract surgery? There are instances where people are dead as soon as you have given the local anesthesia. By the time you remove the needle, they are gone. While giving the discharge summary, the patient, it should be signed by the concerned surgeon or by the CMO or the RMO as the case may be. For post-surgery patients, clear post-operative instructions have to be typed, not handwritten, and given. Now I will talk to you about 1 or 2 cases to make it a little interesting instead of the monotony. These are cases which really happened, which went to the court of law. For secrecy purposes, I am not mentioning who the doctors are. Sometimes you might be able to guess, but even if you guess, just keep it to yourself. MGK is the complainant. MGK actually is not the complainant. Her mother was the complainant. She's a minor versus Dr. RKB. The case put forward by the mother, who is the complainant, that she took her doctor, Miss MGK, to the clinic of the opposite party, meaning Dr. RKB, for treatment of some eye disease for the first time on 8/4/99. Without performing necessary and preliminary tests, without due and proper caution, the doctor operated on the left eye of the child and without proper examination, discharged the patient on the same day. These are the things the patient's mother is alleging. The patient was subsequently taken to his clinic for checkup every morning and evening between 10/4/99 and 13/4/99. On 14/4/99, she was asked to take her to another doctor who demanded rupees 10,000 for another operation on the eye, and also stated that he would not take the responsibility for the complete cure of the eye. Thereafter, the complainant, when I say complainant, the person who complains against a doctor, again called on RKB and informed her that he could do nothing further in the matter. Disgusted, she took the child to SS Hospital, where the doctors told her that in case immediate removal of the eye was not done, the child could die. Accordingly, the child's left eye was removed. Keeping in view the permanent loss of the eye and the physical, mental, and social repercussions it had on her future, being a female child, the complainant prayed for her compensation to the tune of rupees 5 lakhs. So what did Dr. RKB reply? He says, child was initially brought to him on 6/3/99 and not on 8/4/99 as alleged. And on 6/3/99 itself, he had explained to the mother of the patient the serious nature of the problem, and the left eye was already damaged extremely due to the previous surgery. It was only then it was known to her that the left eye of the child had earlier been operated upon at AIMS when the child was 10 months old. Actually, can you believe the mother did not even know that at AIMS a surgery was performed? He got all necessary tests of blood, urine, etc. conducted before the operating on the child. After surgery, the child was kept under observation for 12 hours and discharged only after complete and thorough examinations. Subsequently, follow-up treatment was given from 10/4/99 onwards. Now you would be wanting to know what the judgment was. The complainant, the judge said in his judgment that the complainant had suppressed in her complaint the crucial fact that the child had been operated upon when she was 10 months old. But apparently, probably she was not educated, the mother did not know about it. This was verified through relevant records and examination of the concerned specialist. Except for filing her own affidavit, the complainant had not adduced any expert evidence on her behalf. Reports of the preoperative tests falsify her allegations that they were not performed. The appeal was dismissed with costs fixed at rupees 7,500 on the above grounds. So, don't think that when somebody takes you to court, every time you will be punished. Only thing is, make sure you go to the right lawyer and make sure you present your case properly. See, in this particular case, this particular doctor, Dr. RKB, got away with whatever, we really don't know the real scenario, but he got away with, but these cases have been taken from the books where judgments were given. And this is another case, case 2. This is RD versus Dr. HSC. It was claimed that the complainant had cataract in her right eye, for which she consulted Dr. HSC, who operated her cataract and implanted an intraocular lens and on 24/10/2008. However, the vision did not return in 6 months. Then Dr. HSC suggested that she undergoes, take this lens out and undergoes another implant at a different place. Re-implant was done and separate fees recovered for the same. However, vision still did not improve. Thereafter, on the advice of other doctors, her eye was again operated on 5/5/2009 in another hospital, and the lens was removed and she lost sight in that eye. What was HSC's stand? He denied that a guarantee was given regarding return of vision. The possibility of pros and cons of the operation were explained to her. As the implant did not suit the complainant, another lens was implanted by another operation. Thereafter, the complainant did not come for follow-up treatment. Actually, the patient lost the case just on one point, that she did not show up for follow-up treatment. See, actually, the judges are not really very bad at all towards the doctors, but only thing is we need to be also very conscious of what we are doing to the patients. I really can't understand that one implant did not suit a patient, they take it out, put another implant. It really, something is amiss there. But I think basically we should also be very conscious of what we are doing, and we should be true to our heart. We should not be even thinking about whether somebody will question us, but as long as you are true to your conscience, most of the time it will be, everything right will happen. And the judgment was, the cataract was operated on 24/10/2008. The complainant did not complain of any pain or trouble for 5 months. The complainant agreed to undergo the second operation from the same doctor. Had there been any negligence during the first operation, the patient would not have got the second operation done from the same doctor. From the procedure followed by the doctor, it cannot be interfered that there was any want of care or skill from Dr. HSC. From available records, it seems that the complainant herself was negligent in taking follow-up treatment. So, hence, what did happen? The complaint was dismissed. Now, case number 3. The complainant, a practicing lawyer, got his right eye operated for cataract, but he developed complication and lost his vision in the right eye. Can you imagine somebody operating on an attorney? That's what happens. Ophthalmologist was held grossly negligent for not checking his vision and IOP before surgery. The basis of the quantum compensation awarded is being reproduced for the benefit of everybody to understand how these calculations are made. A sum of rupees, the doctor had to cough up close to 70 lakhs. A sum of rupees 60 lakhs as compensation for loss of eyesight in the right eye, rendering the complainant disabled to the extent of 30%. The complainant in the affidavit had stated that before the loss of eyesight in the right eye, he was an income tax assessee, which after the operation he was not. He was not in a position to strain only the left eye, and his professional income dwindled and had gone down considerably. This had been denied by the appellant. Assuming a monthly loss of rupees 50,000 against his claim of 60 per month, he would suffer a loss of 60 lakhs in 10 years of active life, and the said sum was allowed on this account as a fair compensation for the loss of profit from his profession. Although detailed vouchers in support of 1 lakh claim towards expenditure for treatment was not furnished, a sum of rupees 50,000 was considered a reasonable amount for the cost of account of travel, stay, treatment, etc. And a sum of rupees, note this point, a sum of rupees 25,000 for mental agony was allowed. The complainant maintained a car, and with a disability he could not drive, and he necessarily had to engage the services of a driver, for which he rightly deserved to be compensated. A sum of rupees 5 lakhs again was allowed for this account. See how the lawyers calculate? So we have to be careful. What I'm trying to, the drive home or take home messages, we have to be really, really careful on what we are doing. So there are certain terms which you need to get familiarized with when you know about law. One term is res ipsa loquitur, literally translated like all the other things. This again is Latin. Res ipsa loquitur means the thing speaks for itself. In the case of, this is not an ophthalmology case, but for you to understand what is res ipsa loquitur, I am just talking about this. In the case of Master Ashwin and others versus Manipal Hospital, Bangalore, a 2-month-old child was operated for inguinal hernia and brought out of the operation theater. Parents noticed that he suffered severe burns on both his legs. The State Commission applied the doctrine of res ipsa loquitur and awarded 5 lakhs of rupees as compensation. See, the child was just taken only for an inguinal hernia, but when the child comes out, the child had burns in both his legs. So that means some goof up has happened inside the theater. So this thing speaks for itself, and it was, this doctrine was applied. And where res ipsa loquitur cannot be applied, in the case of Air Commodore Satyanarayana versus L.V. Prasad Eye Institute, the complainant, aged 75 years, lost eyesight of his right eye after cataract surgery, sought to apply the doctrine of res ipsa loquitur. But after considering the material facts and circumstances of the case, the court refused to apply the principle because it said they were unnecessarily, even though in LVP they did everything right, pre-operatively, intraoperatively, post-operatively, whatever they did was perfect and in order. They found it in order, so that particular LVP was not fined for that Air Commodore losing his eyesight. Now the next point which we have to be always worried about is now the real violence against doctors in India. So what are the causes for the violence? See, the poor image of the doctors and role of media, and meager health budget and poor quality of health care. vulnerability of small and medium healthcare establishments, and lack of faith in the judicial process. Because they have lack of faith in the judicial process, they think they can take the law into their hands and act whatever way they can. And what are the causes of violence? Mob mentality, low health literacy, cost of healthcare, really high cost of healthcare, especially in corporate hospitals, and poor communication and lack of security. And they also get telephonic threats, intimidation, oral and verbal abuse, and physical injury, simple and grievous, even amounting to murder. Last year in Kanyakumari, there was a gynecologist who attended on a counselor's wife, and the counselor's wife died of postpartum hemorrhage. The next day, the counselor, he was not in town when it happened. The next day, he apparently came. When she was sitting in the consulting room, he came with a big sickle and just sliced her head and put it on her consultation table. So this is what we have to be, and vandalism and arson. We have to be really worried about all these things. How do you prevent violence? Possible steps, legal steps needed to be taken by the government. Steps that doctors should take, I will tell you. Do not overreach. Consent, documentation, communication. And indications of violent behavior, we use an acronym called STAMP. Staring and eye contact. It looks like you feel like a movie. Staring and eye contact. T, tone and volume of the voice. A is for anxiety. M is for mumbling. And P is for pacing. And restrict entry. And you have to also have standard operating protocols. Your SOPs have to be right. All clinical establishments should develop an SOP for violence. Mock drills need to be conducted. Each member of the staff should be clear of his or her role if the situation of actual violence does arise. And another thing which you should keep in mind is to ensure your establishment against mob violence, damage to property, and injury to workers. And what are the medico-legal challenges in the Indian scenario? Increasing litigations are doctors are because of no limit of liability, complex laws, aggressive increase in patient activism, media glare, lack of structured documentation, lack of medico-legal expertise, no information among the community, no support at clinical stage. And another thing which I find, doctors are used as a very, very soft target, because whoever gets sued by a patient does not confide even with their confidants. They keep to themselves, get into depression, but they don't tell anybody. Unless you tell people, and at least you are well-wishers. You don't have to publicize in the paper, but you can get your near and dear ones to know about it, so that people will give you some ideas or suggestions. And of course, you have to get a good lawyer to fight your case. That is a different story altogether. But when you are sued, don't keep the information only to yourself. Kindly discuss with your near and dear ones and find out what ideas they have. For cases of medical negligence, malpractice, tort, harassment, everything, doctors are a very, very soft target. And 3 out of 10 doctors, remember, is facing an issue every year. And this will grow by 200% annually. But doctors, as I was telling you just now, do not share their concerns, as it is considered a taboo and may lead to tarnishing of their reputation. And India has around 750,000 plus doctors and adds 30,000 doctors every year. And there are another 60 plus medical schools have been just credited for operations. And 84% of hospitals in India have less than 30 beds. The period from 2008 to 2015 has seen an exponential increase in the number of medico-legal cases. against medical practitioners in India. Recently, a lot of cases are getting reported, and one of the recent hearings had an hospital pay a whopping 11 crore penalty along with other criminal proceedings. 11 crore, my dear friends, is not a small sum. The maximum number of cases occurs against gynecologists and surgeons, followed by orthopedicians and dermatologists. The good news here, what is the good news? Less than 5% of ophthalmologists are sued. Cases range from negligence to simple harassment of this trend is slowly moving towards two-tier cities as well. There is only one doctor per 1,700 citizens in India. And firms and individuals in India are currently offering just counseling and legal recourse and do not offer any finer aspects of risk management. So what do we need actually? I find our internal test surveys have found that out of a sample of doctors, most have had some legal issue or the other, are unaware of the risk, while 85% would be very much interested in a service like Legal Advisory Board, very much on the lines of Legal MD, which is there in existence in the US. With no professional firm in the space, a Legal Advisory Board, if it is established, it will be in a position to capture the dominant